Recording in progress. We are about to start shortly, but we kindly request that those at the back should move forward, and those outside should also kindly move forward. There are spaces in front. We'll be, having a coverage so that there will be not too much holes in our midst. Thank you. Oh, thank you so much, and good evening once again. Can we kindly stand as the speaker and the chair take their seats? And kindly put your phones on silent. Thank you.
Please, you may resume your seats. Thank you very much. We'll invite the Honorary Secretary of the Academy to take over proceedings. Thank you very much.
Right. So brief remarks. Good evening, President of the Academy, past Presidents of the Academy, Vice Presidents of the Academy, Fellows of the Academy, Your Excellencies, distinguished guests, students, ladies and gentlemen. On behalf of Fellows of the Ghana Academy of Arts and Sciences, I warmly welcome us all to this evening's lecture. Being day 4 of the 4-day series of lectures marking the 66th anniversary celebrations of the Academy. My name is Professor Adjei, Honorary Secretary of the Academy, as introduced. So, as has been the tradition, we climax the 66th anniversary celebrations of the Academy with the Kwame Nkrumah Memorial Lecture, which is one of the flagship program series of the Academy. I'm pleased to also mention that this program is being streamed live via Zoom, Facebook, as well as on the Academy's YouTube page, and I take the opportunity to also warmly welcome those who have joined us online. By way of background, briefly, the Kwame Nkrumah Memorial Lecture was first delivered in the year 2003 by Professor Alex Edum-Kwapong, whom many of us will recall was the first Ghanaian Vice-Chancellor of the University of Ghana. Professor Kwapong was also very much a foundation member of the Academy, and at the time of delivery of the aforementioned lecture was then chairman of the Council of State. His topic was the Academy's foundations and its role in national development. Another illustrious foundation member of the Academy, Emeritus Professor J.H. Kwame Nkrumah, delivered a 2004 Kwame Nkrumah Memorial Lecture, and the topic was Kwame Nkrumah and the Arts. And since then, we've had this lecture every year, as indeed you may find indicated in the brochure. This year, we are privileged to continue with this tradition, and as we can see, on a topic that must concern all of us. Today's lecture will be delivered by a personality who is a force to reckon with on the subject matter. And indeed, our speaker will be introduced shortly. But my duty here, aside these brief remarks, is to introduce for us the chairperson for the program. The chairperson for the program is Emerita Professor Isabella Achimba Quakyi. Professor Quakyi is the president of the Ghana Academy of Arts and Sciences. She is a distinguished scholar in immunology and parasitology. Educated at Achimota School, she has degrees from the University of Surrey, Brunel, and the London School of Hygiene and Tropical Medicine. She has dedicated 4 decades to teaching research at esteemed institutions, including the National Institutes of Health, Georgetown University, both in the US, Queensland University, and Brisbane, Australia, University of Thailand, and also the University of Ghana here. Professor Isabella Quakyi's groundbreaking research on malaria immunity and vaccine development has earned international recognition. Indeed, her research contributed foundationally to the development of the first human malaria vaccine, the RTSS. She co-initiated and co-led the first NIH International Center of Infectious Diseases Research at the University of Yaoundé 1 in Cameroon. And at the University of Ghana, Professor Quakyi established the Immunology Unit at the Noguchi Memorial Institute for Medical Research. She was the first female director and the foundation dean of the School of Public Health. She has contributed significantly to international research capacity development and leadership, widely published in some of the most reputable journals in her field. Her research fellowships and collaborations span many institutions worldwide, earning her numerous awards and recognitions, including, only mentioning a few, the UNESCO Chair for Women in Science in the West Africa region, and she was, in 2014, the laureate of the African Union Kwame Nkrumah Award for Women in Science. In 2019, Professor Quakyi was awarded the Clara Safmate Ludlow Award by the American Society for Tropical Medicine and Hygiene. And Women's World in 2021 recognized her as one of 7 women in science who have changed our world for the better. She hasn't retired yet. She continues to develop biomedical research capacity and knowledge translation in many areas in public health. With a round of applause, ladies and gentlemen, let's welcome our chair.
Thank you. You can see I'm vertically challenged. Past presidents of the Ghana Academy of Arts and Sciences, vice presidents of the Academy, fellows of the Academy, distinguished invited guests. I think I have more Supreme Court justices around this place than I'd ever cared to have seen. You're all welcome. Distinguished invited guests, students, and listeners online, students, media, ladies and gentlemen, all protocols observed. We have arrived at the penultimate lecture of our celebration of the president who I call Kwame Nkrumah. And all I can say is that I'm humbled that we've reached this far, and to God be the glory. The Kwame Nkrumah Memorial Lecture is in honor of the man who was far-sighted enough to recognize soon after independence the vision to set up an academy of learning to build the needed intellectual capacity to support national development. Indeed, we are the second oldest academy in Africa, aside from Madagascar, and that was how foresighted it was. My task here is a simple one, really, to introduce our illustrious speaker, but I'm allowed to make a few remarks, hence those few remarks. Indeed, our illustrious speaker will be talking on the environmental injustices in poor and rural communities, human rights abuses through pollution and degradation. Our speaker is no other than Sir Justice Dennis Dominic Adjei, FGA, a legal luminary, and I'm about to read just a brief profile. And it is brief. Justice Sir Dennis Dominic Adjei, FGA, is a justice of the Supreme Court of Ghana. Justice Sir Dominic Adjei, is one of the 11 judges of the African Court on Human and People's Rights in Arusha, Tanzania. He is a fellow of the Ghana Academy of Arts and Sciences. He was elected the Inns of Court Judicial Fellowship for senior judges in common law jurisdiction for 2022-2023 academic year. He is the chairperson for the Independent Examination Committee, IEC, the committee responsible for the examination of legal education in Ghana. He has been recently elected as one of the 19 member experts on reparation in Africa by the African Union. He attended University of Ghana and completed in 1991. He entered Ghana School of Law in 1991 and was called to the bar in 1993. He holds an executive master's in public administration from GIMPA, the Public Administration, the Ghana Institute of Management and Public Administration, GIMPA, Accra. He has obtained postgraduate certificate, postgraduate diploma, and a Master of Laws, LLM, in the specialization of criminology and criminal justice from the University of London. He further holds a Master of Judicial Studies, MJS, from the Duke Law School, North Carolina, USA. He was appointed a judge of the Court of Appeal, Ghana, on the 7th July 2010. He has held several positions in the judicial service, including the director of the Judicial Training Institute, the institute responsible for training judges and staff of the judicial service, Director for Public Complaints and Inspectorate Unit, and also Oversight Judge for Western and Central Regions and Ashanti and Northern Sector. He was one of the 9-member advisory committee of International Criminal Court at The Hague, the body that vets candidates seeking to become judges of the court. He was a consultant and chairperson of the first judicial reform in Sierra Leone. He was the first chairperson for the African Judicial Network on Environmental Law, headquartered in Nairobi, Kenya. It's widely published. He has 7 textbooks which are used worldwide. They are International Human and People's Rights, Law and Practice, 2025, Modern Approach to Law on Interpretation in Ghana, 4th edition, 2025, Criminal Procedure in Ghana, 4th edition, 2023, Essential Laws and Credit Creation in Ghana, 2021, Contemporary Criminal Law in Ghana, 3rd edition, 2021, Land Law Practice Conveyances in Ghana, 3rd edition, 2021, Essential Laws on Credit Creation in Ghana, 2022, Constitutional Law of Ghana, Evolution, Theory and Practice, 2020. He has also co-authored a textbook on Alternative Dispute Resolution, 2nd edition, 2025. He has 2 book chapters in 2 renowned books. He has published several peer-reviewed articles in both domestic and international journals. He has presented several conference papers in both international and national levels. He was a Dean, Faculty of Law at the Ghana Institute of Management and Public Administration, GIMPA, Accra. He is an adjunct professor at the Accra Metropolitan University, Accra, adjunct professor at the University of Cape Coast, associate professor part-time at the Kwame Nkrumah University of Science and Technology, and a senior lecturer at the Ghana School of Law at Makola, Accra. He was knighted by Pope Benedict XVI to the Order of St. Gregory the Great in 2005. So audience, this is a speaker for the day, and speaker, your audience. Thank you.
Thank you for the kind words, President of the Academy. Chairperson, who is the President of the Academy, then past President, I can see offhand Nana SKB Asante, Professor Kofinti of the Academy, Vice Presidents of the Academy, distinguished fellows let me acknowledge the presence of Nana Kobina Nketia, the 5. Nana, is it number 5? Good. On my hand of Esikado. We had discussions on telephone, and I told him I will be delivering this lecture. He said, I will attend. And lo and behold, he set off this morning, and he said, Nana, welcome. My lords and ladies, distinguished invited guests, my dear students, good evening. This is a very interesting discussion that we are going to have this evening, and I'm going to discuss it through this outline. I will first introduce the topic, then background, protection and promotion of human rights by Dr. Kwame Nkrumah. Revisiting the records, Dr. Kwame Nkrumah and human rights. Human rights and dignity, Dr. Nkrumah's human rights philosophy. A world awakening promoting environmental rights as human rights. Environmental rights as human rights in Africa. Then United Nations declarations and declaration recognizing water as a human right. Ghana's constitutional environmental justice, environmental pollution and degradation in Ghana, the scourge of the popular gather and sell, galamsey. The effects of illegal mining on rural communities, then the case of Bonte Fufu. People have heard about Bonte Fufu locality. What is it about? The poison called galamsey, our land, their poison. The effects of environmental degradation on human beings, the state's responsibilities to the victims of pollution and degradation. Toxic justice, how illegal mining violates human rights. Moribund effect, a shared responsibility. Then I will conclude. It is a profound honor to stand before this esteemed academy to deliver the Kwame Nkrumah Memorial Lecture. This platform compels us to move beyond mere reflection and engage in a critical, actionable assessment of our national aspirations. As we all know, the caption, Environmental Justice in Poor and Rural Communities, Human Rights Abuses Through Pollution and Degradation. The environment is not a mere amenity. It is an invariable public good and the fundamental basis of human survival. The lecture poses that the current rapid trajectory of environmental degradation in Ghana transcends in ecological crisis. It constitutes a systematic and grievous violation of the human rights of our most vulnerable citizens, particularly those in the poor and rural communities. Shall contend that the disproportionate burden of pollution, ecological destruction, and the resultant health crisis is unfairly imposed upon individuals residing in impoverished and rural communities. This injustice is created by a profound shift from traditional sustainable source stewardship to modern ecological destructive commercial exploitation. The question of environmental protection is, therefore, not merely a policy matter, but a definitive constitutional and moral obligation that requires immediate judicial and governmental action. Ghana, like many developing nations, is grappling with the dual pressures of economic development and environmental protection. While progress is commendable in certain sectors, a darker narrative unfolds in the shadows of our bustling cities and remote villages. It is a narrative of communities often marginalized and voiceless, bearing the brunt of industrial activity, irresponsible resource extraction, and inadequate waste management. Environmental degradation, particularly in the global south, is rarely a neutral process. It is a function of socioeconomic inequality and power dynamics. In Ghana, communities lacking political capital and economic leverage, predominantly poor and rural populations, are subjected to a pervasive form of environmental injustice. This injustice arises when environmental burdens are unfairly distributed and communities are denied participation in decision-making process that affect their ecological space. The lecture moves beyond national policy failures to frame environmental injustice as a direct violation of international human rights law. The systematic exposure of these communities to toxins and degradation fundamentally undermines their basic rights, demanding redress through legal and political mechanisms that prioritize justice and equality. We are going to have a look at Background, Protection and Promotion of Human Rights by Dr. Kwame Nkrumah. I want every student here, law students here, to listen, because some of the textbooks have distorted history. The lecture is presented in memory of Dr. Kwame Nkrumah, a founding leader of the Organization of African Unity, now known as the African Union. The objectives of the African Union include promoting unity and stability among African states, identifying and addressing common challenges, fostering cohesive integration, supporting liberation movements, eradicating colonialism in Africa, safeguarding the sovereignty of African states, preventing external interference in their internal affairs, and ultimately improving the quality of life for African peoples by combating shared adversities such as poverty, underdevelopment, and human rights violations. The founding leaders of the African Union, including Dr. Nkrumah, committed to adhering to the Charter of the African Union and the Universal Declaration of Human Rights to enhance the welfare of the peoples of Africa. And it will interest us to note that African Charter is the first charter on the globe which recognizes Universal Declaration of Human Rights as part of universal rights embedded in the African Charter. The European Commission, they selected some of them. Inter-American Commission, they selected some of them. But Africa, we adopted all of them. Revisiting the records, Dr. Nkrumah and human rights, because we are talking about Dr. Kwame Nkrumah today. This is a proliferation of misinformation about Dr. Kwame Nkrumah's human rights record, perpetuated across generations despite a lack of substantiation for this allegation. The primary criticism directed towards Dr. Kwame Nkrumah pertained to the Preventive Detention Act of 1958, number 17 of 1958, enacted on 18 July 1958. Then, the Deportation Act of 1957, number 15 of 1957, which came into effect on 25 July 1957, and the case of Rui Akoto and 7 others, which is reported in 1961 Ghana Law Report at page 104. So we'll have a brief look at these cases before we proceed to the main lecture, because we have to celebrate Dr. Kwame Nkrumah. Since this lecture addresses Dr. Kwame Nkrumah's human rights record, it is essential to briefly address allegations to clarify misconceptions about the first president of Ghana for younger generations. His designation as Africa's man of the millennium underscores his significant influence on African history, particularly in the struggle against colonialism and imperialism. The Preventive Detention Act of 1958 is a reproduction of the English Emergency Powers Defense Act of 1939, which, among other provisions, conferred extensive powers upon the government concerning various aspects of government, including detention of individuals deemed a threat to public safety or defense without the necessity of evidence or trial, and kept up for up to 5 years without the courts with jurisdiction to intervene. Following Ghana's independence in 1957, the Queen of England maintained the executive power, but the Queen continued to share legislative powers, represented by the Governor General. In the absence of the Governor General, the acting Governor General assumed the powers of the Governor General and performed all functions, including assenting to bills. The two controversial pieces of legislation attributed to Dr. Kwame Nkrumah, that is the Preventive Detention Act and the Deportation Act, both of them were signed by Sir Akukosa and not Dr. Kwame Nkrumah, as we were told in school. And he signed not by his capacity, in his capacity as Chief Justice. He signed in his capacity as Acting Governor General. And as we know, Sir Akukosa served as Acting Governor General in the absence of the fifth heir of Listowel, William Francis Eyre, before becoming the Governor General himself from 6 March 1957 to 13th November 1957, and also became the first Chief Justice from 1957 to 1963. The late Professor Kwakyi, in his decision, which concurred the lead judgment of Professor Ateba in Asare vs. Attorney General, 2003-2004, he queried, why was it signed by Akukosa? He couldn't find the answer. And the answer is that Sir Akukosa was the Acting Governor General, and it was in that capacity that he signed. Therefore, the attribution of these two acts of parliament to Dr. Kwame Nkrumah lacks a basis, as he was neither the president nor the governor general, and did not possess the authority to assent to a bill of parliament to enact it into law. This critical constitutional detail is frequently overlooked in popular discourse, leading to misattributions of responsibility. In the case of Rui Akoto and 7 others, 1961 Ghana Law Report 523, the 8 appellants were arrested and detained on November 10th and 11th, 1959, under an order issued by the Governor General, which was signed on his behalf by the Minister of Interior in accordance with Section 2 of the Preventive Detention Act 1958. When the first Republican Constitution came into effect on July 1st, 1960, the appellants appealed to the Supreme Court to make a declaration that Article 13(1) should override the Section 2 of the PDA because it is inconsistent. Then the Supreme Court was made up of 3 judges. And for the youth who did not know, we had High Court and Supreme Court. There was no Court of Appeal. The Supreme Court, comprising Kosa, CJ, Van Leer, and Akiwumi, unanimously determined that the Preventive Detention Act of 1958 does not conflict with Article 13(1) of the 1960 Constitution. The court held that such legislation may be enacted by Parliament during both peacetime and wartime to prevent the commission of crimes. For this decision, everybody may have his own interpretation and opinion about the judges. But why do we attribute it to Dr. Kwame Nkrumah? It is just to attribute the Supreme Court judgment to the then president, given his non-membership in the judiciary. The principle of the separation of powers requires both executive and the judiciary be held accountable for their respective actions. The Constitution gave the judiciary exclusive judicial power, subject to the Constitution as may be provided by law. So here I'm referring to Article 41 of the 1960 Constitution. Another prevalent yet unfolded argument posits that the judiciary during this period lacked independence and was subservient to the executive. This assertion is starkly contradicted by the historical record. One need only examine the treason trials, that is, State versus Ochre, that is the Kumbungu bombing, a tragic attempt on the life of Dr. Nkrumah. The judges heard the matter. They acquitted most of them. Dr. Nkrumah was not happy. But because he was not one of them, he could not sanction them. The only thing he could do was to get an executive instrument to nullify the decision. So the person in Rui Akoto, we said that the judges were scared of him. What about State versus Ochre? The only power the president had on the judiciary was for the revocation of the appointment of the Chief Justice. And when the president revoked, you became a member of the Supreme Court. It is stated in the Constitution, black and white. The political ramifications of these acquittals were documented. Therefore, I will not elaborate further. However, the logical inconsistency is pronounced. It is intellectually untenable to argue, on the one hand, that the judiciary was under the executive's control, as evidenced by the court ruling in Rui Akoto, while on the other hand, asserting its independence based on its decisions in the treason trial. We cannot selectively interpret the judiciary's independence based on which outcome aligns with a particular narrative. So here, I want us to appreciate the fact that it was in 1964 when the Constitution was amended to make Ghana one-party state. It was during that time that the president had the power to appoint and to sanction judges. Until 1964, when there was a petition against a judge, it will be listed before Parliament. Parliament will debate and vote, and they require 2/3 majority before a judge could be removed. Human rights and dignity in Nkrumah's human rights philosophy. Dr. Nkrumah is one of the few former presidents of the African nation whose quotations are inscribed on the African Court on Human and People's Rights in Arusha, Tanzania. There are only 4 presidents who have their human rights quotations quoted over there. He is regarded as a champion of human rights in Africa. According to Dr. Kwame Nkrumah, the essence of human rights is their role in safeguarding human dignity, as the two concepts are inherently interconnected. If you come to the African court, once you enter, the first inscription on your right, this is what it says, quote, "Sometimes people forget that human rights by their very nature are meant to safeguard the dignity of human beings, wherever they may be. These two principles are suitable bedfellows. To place emphasis on the one to the neglect of the other is to miss the point." Dr. Nkrumah, 8th August 1963. Kwame Nkrumah, The Conakry Years, His Life and Letters, file number 115. This is what we have in the African court. So if the whole continent, we have one court, and that court is responsible for human and people's rights. And we have quotations from 4 presidents on the continent, and we have Dr. Nkrumah as one of them. It speaks volumes. Human rights are fundamental entitlements and freedom inherent to all individuals. These encompass the right to life and liberty, civil and political rights, economic, social, and cultural rights, as well as digital rights. Dr. Nkrumah, akin to other human rights advocates, recognized that human rights include various dimensions. The intrinsic value of human person, necessitating respect for individual autonomy, the protection of fundamental human rights, the equitable treatment of all individuals with dignity, safeguarding individuals from torture, abuse, mistreatment, and exploitation, particularly vulnerable populations in rural communities, including women and children, and ensuring access to essential resources such as food, water, clothing, shelter, and healthcare, free from discrimination based on birthplace, residence, social status, nationality, religion, race, gender, age, or education. He concludes that human rights and the protection of human dignity are inextricably linked. Human rights activists assert that any action undermining the individual's dignity constitutes an affront to human dignity and adversely affects their human rights. The principles of human rights and the safeguarding of human dignity, as articulated by Dr. Kwame Nkrumah, underscore that human rights are fundamental entitlements of the human race. It is evident that human rights and the protection of human dignity are interconnected and interdependent, and their separation is implausible. This principle compels states to promote human rights to bridge disparities between genders, age group, and socio-economic classes, thus fostering a safe and supportive environment that safeguards the well-being of all individuals. Currently, Ghana faces significant environmental crises, particularly affecting rural communities, which include lack of access to clean water and water for domestic use, contamination of soil, fish, water, and crops with mercury and heavy metals, land degradation, exposure to polluted environments due to internal community pollution and environmental racism, insufficient social and economic opportunities, and poor sanitation and hygienic practices. This crisis necessitates a critical examination of the assertion made by Dr. Kwame Nkrumah regarding exploitation of Africans' abundant natural resources, which are extracted for the benefit of the colonial powers, leaving Africans impoverished. He articulated these sentiments in 1965 as follows, quote, Africa is a paradox which illustrates and highlights neocolonialism. Her earth is rich, yet the products of that earth, her people and their craftsmanship are grossly exploited and taken from her and turned against her in a new colonialist interest. Her people are rich in resources and cultural advance, yet their riches are cornered by the exploiters, and their culture and traditions are undermined and belittled, unquote. The quote highlights Dr. Nkrumah's critique of neocolonialism and its impact on African resources, people, and culture. The trajectory of gold, timber, and other valuable resources extracted from Africa, whether through legal or illegal means, ultimately favors the Western world. That is what he said, and it is true. A world awakening, promoting environmental rights as human rights. I'm on the topic now. In 1968, environmental degradation and pollution emerged as significant concerns for human rights advocates and scientists, prompting global attention. A United Nations Declaration on the Human Environment was established in 1968 to create a basis for comprehensive consideration within the United Nations of the problems of human environment, and to focus the attention of governments and public opinions in various countries on the importance of the problem, which was adopted by the United Nations General Assembly and the Economic and Social Council. That is, we look at the ECOSOC Resolution 1346, July 13, 1968. The United Nations Conference on the Human Environment convened in Stockholm, Sweden, from June 5 to June 16, 1972, pursuant to ECOSOC Resolution 1346 of July 13, 1968, to discuss common principles aimed at guiding and inspiring global efforts in the preservation and enhancement of the environment, thereby making it suitable for human existence. The issue of environmental injustice has become a significant impediment to human development, highlighting the necessity of integrating environmental matters into human rights frameworks, whereby states recognize these rights as inherent, and individuals are obligated to respect and safeguard the environment. The extension of human rights to address environmental justice at the conference encompassed two dimensions: the right to individuals to a healthy environment, including access to clean water and air, and the ecological limitations of human rights, which suggest that the exercise of human rights regarding property and economic development must be balanced with the imperative to protect the environment and conserve natural resources. The conference produced a 26-principled declaration to establish a framework for international environmental policy, addressing various aspects, including intersection of human rights and the environment, sustainable development, preventive measures to mitigate environmental harm, international cooperation, and compensation for environmental damage. This declaration was adopted by a vote of 103 to none, with 12 abstentions, notable from the Soviet bloc and South Africa. They were, well, we will not vote against, but we will abstain. The plenary session of the United Nations General Assembly subsequently adopted the declaration on December 15, 1972, as Resolution 2994, with 112 votes in favor, none against, and 10 abstentions, the same group, with the exception of South Africa. The most important quote that we need to observe, Principle 1, it states as follows, and I quote, "Man has the fundamental right to freedom, equality, and adequate conditions of life. in an environment of equality that permits a life of dignity and well-being. And he bears a solemn responsibility to protect and improve the environment for the present and future generations. In this respect, policies promoting or perpetuating apartheid, racial segregation, discrimination, colonial and other forms of oppression, and foreign domination stand condemned and must be eliminated. This is as far back as 1972. Then principle 2, the natural resources of the earth, including the air, water, land, flora, and fauna, and especially representative samples of natural ecosystems, must be safeguarded for the benefit of present and future generations through careful planning or management as appropriate. It was said in 1972. So what steps are we taking to safeguard the environment for the benefit of the present and future generations? The Declaration, which aspires to be the first instrument to enshrine environmental rights as human rights, has attained the status of customary international law due to its universal acceptance and can be cited in various jurisdictions to influence human rights discourse, where you have a practice or where a group come together. Then they make a declaration that, like the Universal Declaration, and it is beneficial and countries start using them. It becomes customary international law and shall have binding effects. It emphasizes the fundamental rights of individuals to adequate living conditions in a high-quality environment that fosters dignity and well-being, asserting that the environment and its natural resources, including water, land, animals, and plants, should be improved, preserved, and safeguarded for both current and future generations through diligent planning. State parties acknowledge the environmental pollution and degradation that they pose threats to human existence on Earth, and urge states to collaborate to further developing international law regarding reparations owed to victims of pollution and other environmental harms occurring within and beyond their jurisdiction. Although declarations are inherently soft law, without legal binding force, they can evolve into customary international law over time. Environmental rights as human rights in Africa. On June 16, 1969, Ghana ratified the African Convention on the Conservation of Nature and Natural Resources of 1968, and consequently signed and ratified the revised African Convention on Conservation of Nature and Natural Resources Treaty of 2003 on 13 June 2007, which dealt with, inter alia, the establishment of conservation areas such as national park, wildlife reserves to protect ecosystems, natural habitats, and wildlife, the protection of threatened species to regulate hunting, the promotion and sustainable management of natural resources, including water and soil conservation, and the recognition of the rights and responsibilities of local communities and indigenous peoples regarding natural resources, alongside their duty to conserve and sustainably utilize these resources. The revised treaty introduced provisions for the participation of local communities in the planning and management of natural resources, the requirement of prior informed consent from local communities for access to genetic resources and traditional knowledge, and the provision for fair and equitable access to benefits arising from biotechnological advancement. Nana SKB Asante. Nana is one of the chiefs who was able to say that I will not allow people to do illegal mining in my area. The African Charter on Human and People's Rights was adopted in Banjul on 27th of June 1981 and came into force on 21st October 1986. The African Commission on Human and People's Rights, also known as the Banjul Commission, served as the treaty body for the African Charter on Human and People's Rights to promote and protect human rights across Africa. As at now, the 55 countries, apart from Morocco, all the 54 countries have signed. But how are they controlling environmental degradation and pollution? Morocco hasn't signed as at now. The African Court on Human and People's Rights was subsequently established to complement protective mandate of the Banjul Commission and has received 34 ratifications from member states, including Ghana. The African Charter is notable for being the first human rights instrument to recognize environmental rights as human rights. Article 24 of the African Charter provides as follows, and I quote, all peoples shall have the right to a generally satisfactory environment favorable to their development, unquote. What people normally ask me is, why is your court called African Court on Human and People's Rights? Human means individual. Individual, your right to life. But when we talk about people's right, environment, and those things, because environment, one person cannot say that, destroy the environment and I will compensate you. It is the right for everybody. So it is the first continent to have a charter that deals with people, human and people's rights. So Article 24 not only enshrines human rights, but also embodies a corrective right, as it is granted to the entire community and cannot be compromised by a subset of it. The article obligates state parties to prevent environmental pollution and degradation, while promoting conservation to achieve ecologically sustainable development and the effective use of natural resources. Let's look at the case of socio-economic rights. That is the Action Center and another versus Nigeria. We are aware of what happened in Nigeria when the oil spill. Some people lost their life. They went to the African Commission on Human and People's Rights in Banjul to determine the state's responsibility towards its nationals. Noted that when a state fails to take appropriate measures to prevent environmental pollution, it contravenes its obligation under Article 24 of the Charter. Then this is what the African Commission on Human and People's Rights said, quote, the right to a generally satisfactory environment under Article 24 of the African Charter imposes a clear obligation upon a government. It requires the state to take reasonable and other measures to prevent pollution and ecological degradation, to promote conservation, and to secure ecologically sustainable development and the use of natural resources, unquote. Ghana is also a signatory to the International Covenant on Economic, Social, and Cultural Rights. That is one of the UN treaties that have been fully subscribed. As at now, it's about 120 countries have ratified it, which imposes an obligation on state parties to ensure the preservation of the environment to allow their nationals to attain the highest standard of physical and mental health. Article 12 states as follows, quote, the state parties to the present covenant recognizes the right to everyone to the enjoyment of highest attainable standard of physical and mental health. 2, the steps to be taken by the state parties to the present covenant to achieve the full realization of this right shall include those necessary for A, reduction of infant mortality, the provision for the reduction of the stillbirth rate and infant mortality, and for the healthy development of the child. B, environmental hygiene, the improvement of all aspects of environmental and industrial hygiene. 3, disease prevention control, the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases. 5, medical care, the creation of conditions which will assure to all medical service and medical attention in the event of sickness, unquote. The United Nations Committee on Economic, Social, and Cultural Rights, the treaty body of the International Covenant on Economic, Social, and Cultural Rights, issued General Comments number 14 on July 28, 2010, to clarify the right to a healthy environment, emphasizing the necessity of preventing and reducing population's exposure to harmful substances such as radiation and toxic chemicals, including mercury and heavy metals, as well as other detrimental environmental conditions that may directly or indirectly harm human health. Let's look at United Nations declarations and declaration recognizing water as a human right. Initially, water was not a human right. It was considered as a mere environmental right. Now, on 26th of July 2010, the United Nations General Assembly adopted Resolution A/RES/64/292, declaring the right to safe and clean drinking water as a human right that is essential for the full enjoyment of life and all human rights. I'm going to talk about matters that people are going to ponder over them. The resolution highlights several critical aspects of water, including the individual's right to access sufficient quantity of water for personal and domestic use. Approximately 50 to 100 liters per person per day. That is clean water. Everybody, you're entitled to 50 to 100 liters per day. It also emphasized the necessity for water to be safe and clean, free from microorganisms, chemical contaminants, and radiological hazards that pose a threat to human life. Furthermore, the resolution stipulates that access to clean, safe water should be within 100 meters of a person's home, with correction time not exceeding 30 minutes. Let's go to the rural areas. You will travel for about 2 hours and you go and fetch Milo. Garamsey has converted our rivers into Milo and Overton. Additionally, the cost of clean, safe water should be affordable, not exceeding 3 to 5% of a household income. How much do we spend on pure water? And sanitation facilities must be hygienically safe and adhere to minimum standards for the right to clean, safe drinking water and sanitation. This is UN resolution. In October 2021, the United Nations Human Rights Council adopted a resolution recognizing the right to a safe, clean, healthy, and sustainable environment. Do we have that one in Ghana? We'll come to it soon. 6, we are talking about Ghana's constitutional environmental justice. The Constitution of Ghana 1992 contains 2 principal provisions concerning the environment, specifically Article 36(9) and 41K. Article 36(9) states they fall within the directive principles of state policy. And 36(9) states as follows, quote, "The state shall take appropriate steps needed to protect and safeguard the national environment for posterity, and shall seek cooperation with other states and bodies for the purposes of protecting wider international environment for mankind." This is our own constitution, unquote. This directive principle of state policy emphasizes the obligation of the state to implement appropriate measures for the protection and safeguarding of the environment for both current and future generations. Whenever I talk about the directive principles, the name that comes to mind is Professor Ateba. When he was on the bench, there was a confusion whether it was justiciable or not justiciable. And he was bold to say that they are, my students are looking at me, they are presumptively justiciable. Then every citizen of Ghana has a duty to contribute to the nation's development, which includes environmental protection. Article 41K of the Constitution pertains to the responsibility of citizens, stating, quote, 41, "The exercise and enjoyment of rights and freedom is inseparable from the performance of duties and obligations, and accordingly, we shall protect and preserve environment." Unquote. Let's look at environmental pollution. We have read charters that Ghana has ratified. We talk about our own constitution. Let's look at environmental pollution and degradation in Ghana. It is the duty of every citizen to protect and safeguard the environment in accordance with Article 41. Every citizen of Ghana who enjoys the rights and freedoms of the nation is mandated to fulfill their patriotic responsibilities by protecting and preserving the environment thereby creating conditions conducive to development. This establishes a symbiotic relationship wherein the state's obligation to protect the environment is mirrored by the citizens' duty to safeguard it, thereby forming a dual foundation for environmental justice. The scourge of Galamsey. Illegal mining is predominantly practiced in the rural regions of Ghana, where local populations primarily engage in agriculture and fishing as their main sources of livelihood. Notable areas for illegal mining in Ghana: Ashanti region. We have Amansia West region, Manson Kwanta, my own region, my own district. Amansia East, Amansia Central, Jakobu. Amansia South, Manswe Dubia, Atwema, Mpunua, Nyinehini, Atwema, Nwabieja, Nkawie. Atwema, Nwabieja North, Barakese. Asante Achem North, Agogo. Asante Achem South, Municipal, Jaso. Asante Achem South, Municipal, Konongo. Obuasi East Municipal, Tutuka. Obuasi Municipal, Obuasi. Adanse Asokwa District, Adanse Asokwa. Adanse North District, Formina. Adanse South District, New Edubiase, and Bosome Frehon District, Esiwa. These are primarily rural communities whose economies are based on farming and artisanal practices, and now Galamsey has taken over. All 9 administrative districts in the western north, including Awurin Municipal, Enchi, Bia East District, Sehui, Adabokrum, Bia West District, Isam, Debiso, Bibiani Anyaso Bekwai Municipal, Bibiani, Bodi District, Sehui Bodi, Dwabeso District, Dwabeso, Sehui Akontomra District, Sehui Akontomra, Sehui Wioso Municipal, Sehui Wioso, and Swaman District have been adversely affected by illegal mining. All the districts over there. The aforementioned districts in the Ashanti region, alongside with all districts in the western north region, eastern region, central and western regions, which were previously utilized for agricultural production of food crops and cash crops, including cocoa and palm trees, are now being exploited for illegal mining. Furthermore, nearly all the rural districts in eastern region, western region, upper west region, upper east region, and central region, once primarily agriculture, are currently being repurposed for illegal mining activities. This phenomenon has reached a national scale, systematically transforming the nation's agricultural landscape into one characterized by pits and contaminated waterways, because you will find only pits. The chemicals predominantly utilized in illegal mining in Ghana include mercury and cyanide. And as we know, mercury is a toxic element employed in the extraction of gold from ore, whereas cyanide is utilized to dissolve gold during the mining process. These are the minerals being used by illegal miners. Environmental degradation refers to the decline in environment quality, typically resulting from human activities or natural processes. The repercussions of such degradation encompass land degradation manifested through nutrient depletion, salinization and soil erosion, water pollution, air pollution through atmospheric emissions, loss of biodiversity, and climate change. The primary drivers of environmental degradation attributable to human actions include industrialization, urbanization, population growth, consumption patterns, illegal mining, particularly in Ghana and some of the neighboring countries. Let's look at the effects of illegal mining on rural communities. It is settled that many environmental rights have evolved into human rights. Melissa Tome, an advocate for environmental justice, who considers ecological rights to be human rights, posits thus, quote, "Environment as a human right refers to a safe, healthy, and ecological balanced environment," unquote. Despite the significant adverse effects of illegal mining on water bodies, human health, and agricultural practices, individuals engaged in this illicit activity continue their operation to enhance personal wealth, thereby attracting others to participate without regard to the health implications for impoverished and vulnerable population within impacted communities. Mercury presents substantial risk to individuals involved in illegal mining and to local communities through mechanisms such as water contamination, bioaccumulation within the food chain, and inhalation of vapors. The application of cyanide in gold dissolution results in leaching into groundwater and rivers, endangering aquatic life and rendering water sources unsafe for human and animal consumption. The chemicals employed in illegal mining, primarily mercury and cyanide, impose considerable health burdens on affected populations, resulting in severe illness, permanent disabilities, reduced life expectancy, and premature mortality. The extensive damage these substances inflict on human health and the environment demands immediate, decisive intervention to stop it. It is essential to prioritize prohibiting their use to ensure that all individuals live free from toxic pollution, preserving their fundamental human rights to a safe and sustainable environment. Furthermore, it is imperative to acknowledge the significant economic disparity that underpins this crisis. The financial resources for excavators, generators, and hazardous chemicals primarily come from external sources rather than from the rural communities themselves. In contrast, the labor force engaged in these activities, predominantly young men and women who operate in mining pits and manage the toxic slurry, largely originates from local impoverished and vulnerable populations or from similarly disadvantaged individuals neighboring communities. This situation creates a destructive twofold impact on these communities. First, land and water contamination undermine the livelihoods of framers and fishermen. Second, the allure of rapid financial gain from mining diverts youth from traditional occupation, resulting in significant gap in the next generation's capacity to sustain environmentally sound livelihoods such as agriculture and fishing. The tragic irony resides in the fact that while these young individuals may perceive themselves as earning considerable income in the short term, they ultimately incur a far greater cost because they are going to fall sick whether they like or not. The seemingly generous compensation is a deceptive facade, exchanged for a future characterized by chronic illness and disability, resulting from prolonged, unprotected exposure to mercury and cyanide. In a sense, they are sacrificing their long-term health and very lives for ephemeral financial gain. Environmental justice includes the right to safe, healthy, aesthetically pleasing, ecologically balanced, and sustainable environment. The right to a sustainable environment encompasses the following rights. The right to an environment that is clean, safe, and healthy, and not harmful. The right to development, that means the needs of the present without compromising the health needs of the future generations. The right to environmental protection, including the prevention of environmental degradation, preservation of natural resources, and conservation of biodiversity. And the right to access information regarding environmental issues that affect individuals, as well as right to participate in decision-making process. I'm going to talk about a community. Why have I selected the case of Bontefufuo? Bontefufuo is not far from Kumasi. It is about 18 miles away from Kumasi. And it is made up of 12 communities I'm going to talk about. The word Bontefufuo is like white water. Bonte white. Bonte, which is colorless. Bontefufuo. It's situated in the Amansia West District of the Ashanti region. Encompasses 12 towns. Mosianso, Esuonyum, Ahrewa, Isanse, Menshia, Abuabo, Tetekaso, Tetrim, Mpatuam, Bonte, Sudianinso, and Akateniase. The Bonte River traverses these towns and historically served as the primary source of potable water for the entire community, earning the designation Bontefufuo for its clear, colorless water. However, illegal mining activities have critically impacted on the Bonte River, its beds and waterways, effectively rendering it non-existent. Documenting the river's extension does not require video evidence, but I brought one. If you visit Bontefufuo, you will cry. River Bonte, which passes through 12 towns, is no more. You cannot even trace the waterways. A pressing question arises about the current water sources for the residents of Bontefufu. Community members are compelled to buy bottled mineral water from Kumasi because the local boreholes have become contaminated. Those who cannot afford this option resort to drinking water from the wells they have excavated themselves, which are also likely contaminated. It is essential to consider the broader implication of mining activities, particularly the effects of illegal mining on local communities and rural areas where such activities are prevalent. The poison called galamsey, our land, their poison. The detrimental effects of mining activities on local populations have been extensively documented in various academic sources. For instance, Leslie Sponsel, one of the popular human rights activists, in his chapter titled Thief, Gold Mining and Mercury Contamination in the Amazon. He called it Thief. Thief, Gold Mining and Mercury Contamination in the Amazon. This one nobody can challenge it because it has undergone test and it has proved to be true. Elucidates that metallic substances and mercury can enter the human body through multiple pathways, including inhalation of vapors, dermal absorption while handling mercury and good slurries, and gastrointestinal absorption from contaminated dust or water that comes into contact with the hand, food, or cooking utensils. Furthermore, bioaccumulation within the food chain poses significant risk, particularly for vegetables sourced from rural areas, which constitute primary dietary components. I've seen researchers from Ghana saying that kontomire from Konongo areas, and I heard some contradicted opinions. But this one is coming from Amazon. And it says that, furthermore, bioaccumulation within the food chain poses significant risk, particularly for vegetable sources from rural areas, which constitute a primary dietary component. It is not from Ghana. So how do we rebut this assertion? When substances such as mercury, heavy metals, and other toxins gradually accumulated in the tissues of living organisms through ingestion, they can persist within the body and increase in concentration as they ascend the food chain. Primary producers absorb these harmful substances from their environment. Herbivores consume contaminated plants, thereby ingesting the accumulated toxins. And carnivores that prey on herbivores further accumulate these toxins within their system. Unfortunately, apex predators, including human beings, experience significant bioaccumulation of these hazardous substances. I've provided the sources, all from outside Ghana. According to the publication, the primary indirect pathway for mercury exposure is through the regular consumption of contaminated food, including vegetables and fish that contain metal mercury derived from polluted water bodies, rivers, wells, and rivulets. Illegal miners and their buyers experience direct contamination with metallic mercury. At the same time, individuals in rural communities who rely on these food substances or food sources face indirect contamination, which poses a more hazardous form of metal mercury exposure. Mercury poisoning manifests a range of symptoms. I'm quoting from some of these authorities. The master thief, gold mining and mercury contamination in Amazon. Then pathological effects of mercury poisoning in the biochemistry of mercury. Then the biochemistry of mercury, New York, 1979. The combination of the three sources provide as follows. Mercury poisoning manifests a range of symptoms that are contingent upon the specific type of mercury involved and whether the exposure is acute or chronic. Additional factors influencing symptomology include the age of the affected individuals, adult, children, and fetuses. Variations in body size. If you are like me and somebody is small. Absorption rates and psychological susceptibility. Research indicates that chronic exposure to metal mercury can lead to numerous symptoms, including skin irritations, low-grade fever, headaches, nausea, diarrhea, fatigue, insomnia, irritability, and a significant decline in sensory acuity, such as vision, hearing, smell, and touch. Severe cases may culminate in blindness, impaired speech, memory loss, premature senility, manic depression, renal issues, debilitating tremors, brain damage, and potentially death. Metal mercury does not remain within pregnant women, as it rapidly traverses the placenta to accumulate in the fetus, resulting in mercury concentrations that are higher in the fetus than in the mother, who may otherwise appear healthy. The mother may appear healthy. The several abnormalities associated with mercury exposure in fetuses include stillbirth, spontaneous abortions, significant birth defects, paralysis, physical impairments, and cognitive disabilities. Mercury poisoning is particularly prevalent among children. For example, a child weighing 20 kilograms must consume only between 10 and 20 grams of carnivorous fish to develop mercury poison. This insidious nature of poisoning underscores the vulnerability of the unborn, infants, and children, who are disproportionately at risk of enduring lifelong healthy complications. The effects of environmental degradation on humans. The consequences of environmental degradation on human health are significant. Health-related issues arise from waterborne diseases caused by contaminated water sources, including cholera, typhoid, and dysentery. Additionally, air pollution contributes to respiratory disorders, including pneumonia and asthma, as well as cardiovascular complications resulting from exposure to various pollutants. Further repercussions of environmental degradation include food insecurity, which leads to malnutrition and diminished crop yields, as well as water scarcity. Water scarcity that renders water sources unsafe for human consumption, adversely affecting agricultural practices. Moreover, environmental degradation heightens vulnerability to climate change and contributes to biodiversity loss. The human cost of these effects is immeasurable. However, the economic implications overlooked are substantial. Preliminary estimates may include long-term health care expenses associated with children suffering from mercury-induced neurological damage, the decline in agricultural productivity due to land degradation, and the financial burden on the state for importing food to compensate for diminished local production. When juxtaposed with the short-term revenue generated by illegal mining, it becomes evident that the nation is engaged in a detrimental economic trade-off, sacrificing its long-term capital for transient gains. This approach cannot be characterized as development. Rather, it represents liquidation of the national estate. The state's responsibilities to the victims of pollution and degradation. The state bears a fundamental responsibility to enforce its laws alongside its obligations under international law. The established standards of international human rights assert that state has fourfold obligation to its citizens to respect, protect, promote, and implement the human rights treaties it has ratified. In fulfilling these obligations, the state must refrain from committing human rights violations and protect rights holders from violations committed by third parties. State obligations to safeguard human rights encompass the establishment of criminal legislation, supported by an enforcement mechanism, as well as the conduct of judicial inquiries to ensure the practical application of domestic laws, protecting victims from violations by third parties, state agencies, or organs. The African Court has delivered several judgments. The latest one, which I was on it, is the Lido against Côte d'Ivoire, where Côte d'Ivoire allowed people to deposit contaminated materials, and about 1,000 people died, and others became maimed. We awarded huge sums of money against Côte d'Ivoire to pay to those affected, because you have a duty to protect your citizens. These illegal miners obstruct waterways, as has happened in Bontefufu and Ankobra, and contaminate rivers and aquatic ecosystems, often with the awareness of certain traditional leaders and state security agents. They appear to be shielded from legal repercussions, leading to the state's potential liability for human rights violations perpetrated against rural communities. The human rights violations stemming from pollution and environmental degradation encompasses the right to life, health, a clean environment, information, and economic and social rights, including the rights to food, water, and livelihood. These violations disproportionately affect vulnerable populations, particularly those in impoverished and rural communities. Toxic justice, how illegal mining violates human rights. The pollution and environmental degradation resulting from illegal mining infringe upon local communities' rights to life and to physical and moral integrity. Both the state and individuals engaged in illegal mining are aware of the detrimental effects of these activities, but have failed to take reasonable measures to mitigate the risk posed to the right to life. Article 4 of the African Charter, which Ghana has ratified, provides as follows, quote, "Human beings are invulnerable. Every human being shall be entitled to respect for his life and the integrity of his person. No one may be arbitrarily deprived of this right," unquote. The right to life serves as foundation for all other rights and freedoms, and ramifications of pollution and degradation on human existence are profound. The United Nations Human Rights Committee, in its General Comment number 6, its General Comment number 36, outlines the fourfold obligations of the state to protect right to life. It says, quote, "State parties must establish a legal framework to ensure the full enjoyment of the right to life by all individuals. As may it will be necessary to give effect to the right to life, the duty to protect the right to life by law also includes an obligation for state parties to adopt any appropriate laws, other measures, in order to protect life from all reasonably foreseeable threats, including those emanating from private persons and entities." Most people engage in the illegal mining, they are third persons, and the state has a duty to ensure that they are arrested and prosecuted. The state is obligated under international human rights treaties to safeguard victims of human rights abuses, particularly concerning the right to life. The state bears the obligation to ensure that its nationals are entitled to enjoy the highest attainable standard of physical and mental health. The detrimental effects of mercury, metal mercury, and heavy metals on individuals, including adults, children, and fetuses, as previously discussed, underscores the state's duty to eliminate barriers to the exercise and enjoyment of the right to physical and mental health. Prof. Chair, Article 16 of the African Charter articulates the following, quote, "Every individual shall have the right to enjoy the best attainable state of physical and mental health." 2, state parties to present charter shall take necessary measures to protect the health of their people and to ensure that they receive medical attention when they are sick. Now, Garamsey is making them sick. Do they get proper medical attention? The African Commission has observed that the enjoyment of the human right to health is essential to all phases of individual life and well-being. serving as the foundation for the realization of all human rights and freedoms. This is a case which was brought before it against Egypt. The state contravenes its obligations to its national, particularly in rural and impoverished communities, by permitting illegal mining and its associated ramifications. This failure is evident when the state fails to enact appropriate legislation, enforce regulations effectively, and protect individuals from harmful actions by third parties that infringe on their right to the highest attainable standard of physical and mental health. The state violates its international human rights obligations whenever it fails to implement necessary measures to safeguard individuals within its jurisdiction from third parties to violations of their right to health. Moreover, it must ensure that victims have access to available, accessible, acceptable, and quality medical treatment. Individuals in impoverished rural areas who experience physical and mental health issues due to illegal mining lack access to quality medical care, as existing facilities are predominantly rudimentary compounds that qualified medical practitioners do not manage. A state that fails to prevent illegal mining and its adverse effects on its national and further neglects to provide those affected by such disasters with full access to quality health care shall violate Article 16 of the Charter. It provides as follows. The decision. The state violates its international human rights obligations under Article 24 of the Charter, which mandates the provision of a generally satisfactory environment for individuals within its territory. Evidence clearly indicates that pollution and environmental degradation resulting from illegal mining and related activities have dire consequences, including contamination of groundwater and river bodies that serve as primary sources of drinking water and domestic water for rural and impoverished community. This one, you will find it in the same article, Master Thief, Gold Mining and Mercury Contamination in Amazon. And the General Comment 14, issued by the Committee on Economic, Social, and Cultural Rights. The state is obligated to promptly and effectively remediate polluted sites to fulfill its responsibility to safeguard and uphold the right to a satisfactory, conducive environment that will help people to develop. The contamination of the human body by metallic mercury can occur through various pathways, including inhalation of vapors, dermal absorption during handling of mercury and good straws, and ingestion when dust or water containing mercury comes into contact with eating utensils, food, or hand. The society expresses grave concern regarding the escalating environmental degradation in Ghana over recent years due to illegal mining and consequent adverse effect on children's health, future livelihoods, and national sustainability. 3. The right to information regarding impacts of illegal mining is enshrined in Article 9 of the African Charter of the International Covenant on Civil and Political Rights. 2. This right guarantees an individual access to public information on matters or procedures that affect them. However, impoverished and rural communities in areas impacted by illegal mining remain uninformed about the effects of mercury, metal mercury, and other toxic metals, as well as their ramifications for both people and the environment. The state is required to investigate the impacts of mercury and other hazardous metals, including their actual and potential implications for human rights, and to inform affected individuals about consequences for their health, environment, crops, and livestock. This is not just a moral obligation. It is a legal obligation because Ghana has ratified the International Covenant on Civil and Political Rights. Furthermore, the state has an international human rights obligation to make information concerning public health and other civic matters accessible to its citizens, including data on the implications of such information. A failure to provide this information and to educate the populace about their rights constitutes a violation of the right to information. The African court, we have judgment on it. Then European court too has judgment on it. That if something affects the right of the individuals and you fail to educate them and inform them, you violate their right to information. Moribund effects. The preceding discussions hold significant implications for individuals residing in rural communities whose human rights have been systematically violated, continue to be infringed. The state has a responsibility to abolish illegal mining activities and mining operations within forest areas. Now the forest one is gone. To safeguard the lives of individuals in impoverished and rural communities. The official one is gone. What about the illegal miners in the forest areas? It is still going on. This situation arises through no fault of their own, as it is economically privileged who engage in illegal mining and subsequently escape the adverse effects of the resultant pollution. They go there, they mine, they get their money, they leave. What about the fate of the rural poor? Currently, individuals in urban areas are unable to secure a reliable source of food, including fish and vegetables, highlighting the urgent need for collective action to combat the Galamsey crisis. The government bears a negative duty to refrain from engaging in practices that result in pollution and environmental degradation, which pose significant risk to human life and health. Furthermore, it is imperative that government protect individuals within its jurisdiction from environmental hazards caused by its own actions or by third parties. This one is part of the state's international obligations. Shared responsibility. The Galamsey crisis is perpetuated by a compressive web of complicity. The urban financier who supplies capital for excavators, they bring in Chinese. The political patron who offers protection, the elite who adorn themselves with gold jewelry, and the international markets that demand the mineral without scrutiny. Consequently, the pollution of Ankobra River is also a shared responsibility of corporate boardrooms in Accra and their refineries located abroad. Until this comprehensive chain of accountability is recognized and addressed, efforts to mitigate this issue will remain superficial. The struggle against Galamsey represents a confrontation with a deeply entrenched network rather than merely isolated individuals. Accordingly, all relevant state agencies involved in enforcing laws against illegal mining, including security personnel, environmental protection officers, the judiciary, the Office of the Attorney General, must exhibit the fortitude necessary to ensure compliance with safety regulations and standards, and to impose substantial penalties on those who violate them. The rights of the victim adversely affected by illegal mining may be asserted against the state if it fails to fulfill its international human rights obligation to eradicate the illegal mining crisis. Remedies. Remedies are awarded against the state for its failure to uphold. These obligations may include restitution, compensation, rehabilitation of victims, measures to prevent recurrence of violations, formal apologies, and the construction of memorials to address the ongoing calamity, contingent upon the specific circumstances of each case. The Côte d'Ivoire one, we made several of these orders. I conclude, but after my conclusion, we'll get the opportunity to watch 5 minutes or 3 minutes video on illegal mining. The struggle against Galamsey transcends more environmental or legal consideration. It constitutes a fundamental moral imperative to uphold the dignity and rights of every Ghanaian, as articulated by Dr. Kwame Nkrumah. Dr. Kwame Nkrumah envisioned a Ghana that was not only free, but also prosperous and self-sufficient. He aspired for a nation that will harness its resources for the benefit of its populace. The current trajectory of environmental degradation represents a profound deviation from that vision. We must embark on a corrective national restoration initiative, very much along the lines of the Green Ghana project. This necessitates the courage to hold powerful entities accountable, the innovation to rehabilitate degraded lands, and the commitment to invest in sustainable rural communities. Let this lecture be remembered not merely as a diagnosis of profound injustice, but as the pivotal moment when we mastered the political and moral fortitude to reclaim our birthright, a healthy environment where the dignity of every Ghanaian, from Bontefufuom to cantonments, is recognized as an inviolable human right. We must unite in the fight against illegal mining, which poses an existential threat to impoverished and rural communities that serve as the primary providers of food and vegetables for urban populations. The loss of human lives and the deterioration of health resulting from illegal mining activities cannot be justified by the monetary gains accrued by individuals or by the state. Prof, Emerita, President, I'm done with the lecture, but I want us to have just 5 minutes. Watch a video on illegal mining. So this is Ankobra. That is River Pra before activities of Garamsey kicked in. Then Ghana's dead rivers. The rivers are dead. Kwame Adjei Ameno. That is his pictorial representation. Please come again. Reverse. Isansi Bontefufuo. Now, what we see over here, Ankobra, whether Ankobra or Bonte, Bonte is no more. What you see there, the trenches made by the illegal miners, and this is the color of the rivers and the water bodies that some of them drink because they cannot afford mineral water. Continue. Bonsa River. You see how it has been polluted. Then an area view shows a small-scale gold mining site in Takwa. Then a young boy washes gold to separate it from other metals. He's infected. Then, so credit web, Secretary Bonza. I mentioned Bonza. So, illegal mining at Bonza. This one is Bosomepre in Ashanti region. Look at what the human beings are doing and look at the river bodies, how they have polluted them. Ankobra River. Ankobra, as you know, from the Bibiedi forest through, those days when we were young and we visited our uncles in Sekri area. That was our main source of drinking water. So that is Ankobra for us. So we give credit to the Prof estate. Look at how the illegal mining is done. We are talking, they are using mercury, but they don't know its effect. And even if they know, they are interested in the money that they will gain within the shortest possible time. Then they will use whatever they get to cure the damage that they will suffer. I think it is enough. We have seen enough and we've heard enough. So, Madam Chair, thank you, and the audience, thank you for your attention.
The Offin River is highly polluted downstream. But upstream at the Barikasi Reservoir, the river is clean.
This is the Barikasi Reservoir or dam. This place supplies 80% of Kumasi with water. In fact, 20 to 25 million gallons of water are pumped daily from this treatment point. Now, this is the Ofin River, and it is the upstream of that water source. 5 tributaries join.
Can we give a standing ovation, please? A standing ovation. This is simply the amount of, really, thank you so much. Thank you so much, said Dennis. This is simply amazing. And I think we just have to give opportunity to, just as students, to even ask questions. We've learned such a lot. I think from here we should all be, card carrying, stop Galamsey immediately. So we can give one round of 5 questions. And please, when you get up, you say who you are and where you're coming from, and your short question, not another lecture. Thank you.
Good night, my family, my African family. My name is Kojo Asara Bonsu. I'm an African that was born in Jamaica, living in the UK, and now back to my ancestral land. I'd like to say that the issue of planet repairs and the issue of African reparation is something dear to our heart as the children of Africa living outside of Africa, and especially in the UK. I am part of a group in the UK, the Global African People's Parliament, which supports the idea that we need to be harmonizing the voice of African people globally, including Ghana, and also a campaign which is Stop the Manganese We Charge Ecocide Genocide Campaign, which is to bring the attention to the British government the need for all-party parliamentary commission of inquiry towards African reparation. I'm humbled to be here this evening because it highlights that the issue of African reparation and planet repairs is an African international event and not necessarily fragmented and segregated in different areas. So my question is, when will we stop the international exploitation and removal of African resources that is damaging our lives, our livelihood, and our environment?
Thank you. Second one. Next
question. Thank you very much. My name is Sika from Radio University of Ghana. A very brilliant submission, Prof. My question is, would you subscribe to those who are advocating for the setting up of environmental courts that deal expeditiously with these cases of illegal mining? And then the second one will be, at which point do we draw the line between economic viability and our survival? Thank you.
Thank you. A third. The students, one student over there.
Good evening. My name is Victor John. My question, I'm a student of Laboni Senior High. Now my question is, now we know the problems of Galamsey.
Please step a little back from, we can't hear you too well. Yes.
Okay. So now we know the problems of Galamsey. And now what can we do to fix the water bodies that the problems of Galamsey have caused? And my second question is, during his presentation, he spoke about African Charter. So I want to know what the African Charter is about. Thank you.
What it's about? What the African Charter is about? Thank you. All right. The fourth. fourth question. Okay, someone here.
Hi, good evening. My name is Sylvester Honey. My Lord, respectfully, if you were to advise the government about what to do based on the lecture you have given, the problems you have identified and everything, what would be your candid advice to the government? Because one time people stop, and another time you realize that they go back to the same river going to mine. So if you're supposed to advise the government of Ghana about this issue, what would be your advice? Thank you.
Okay. And the last question, anyone brave enough? Students, giving you a chance to question. Okay, I think we'll go with the four. No, you can sit comfortably.
Prof. Adjei, may I ask what happened 3 days ago? Do you have a question? All right, let me start from the first one. So, when do we stop international exploitation? You know, this has been a long-standing battle to fight. They are well-to-do. We go to them for loans, for aid, and they exploit. But some of the treaties require them. For example, if it is forestry and lumber is being sent outside, and it is coming from illegal source, it should not be allowed to be in the European market. What about gold? Can't we have such a policy that gold in the European market, which are coming from illegal sources, should not be patronized? So the measures to be taken, the disadvantage is that the African, we have a weaker bargain as against the Western world. And if you are bargaining with them, you know, it becomes very, very difficult. Now you talk about the African Caribbean reparation. Now we are about to start. As I have been elected as one of the 19 experts from Africa. So now where do we start? Where do we end? People ask me. After our election, they ask me, now how are you going to seek reparation for the damage caused to the continent? Over 200, 300, and even recent events. How are we going to address? So I believe it is by the combined effort of the African and Caribbeans. And some of the Western world are in support that you have long been exploited. And we all know when the British were leaving Ghana, then the amount of gold that they took. Recently, when Asante Hene wanted to celebrate his anniversary, his own artifact, which they took from him, he had to go and plead with me, to plead with them, please, give it to me to go and celebrate. After that, I will return it. So these are some of the things that we are facing. Then, those advocating for environmental courts. We established environmental courts in Ghana in 2016. During the time of Chief Justice George Wood. I was the Director Judicial Training School, and I had the opportunity to train some of the judges who were to sit in those courts. But in about 2, 3, 4 years ago, it seems the court has phased out. But it does not mean that if somebody commits environmental offense, the person will go scot-free. We have courts of general jurisdiction. Any high court can entertain. And if you go to the semi-urban areas where we have the district courts, they can. Circuit court. In most of the illegal mining, illegal offenses, district courts jurisdiction have been ousted. Let me tell you one interesting case. When some people were engaged in illegal mining in Takwa some years back, they were arrested by the police. And there is high court in Takwa, circuit court in Takwa, district court in Takwa. They intentionally preferred a charge of trespass against them to the district court. So that, assuming they are convicted, the sentence will not be more than 2 years. The former Chief Justice, Georgina Wood, when she heard about it, she called me as the director for the training school, that I should make an inquiry. I called the magistrate, he brought, and the facts of the case, they omitted the illegal mining and presented the facts on trespass. So, if you look at it, well, then those advocating for environmental causes, yes, and the difference between economic sustainability and injuries arising from illegal mining. You know, you cannot buy human life with any amount of money. That is why the African Charter says that life is inviolable. Interestingly, I was one of the judges on the panel who even held that to say that somebody should die through hanging is a violation of that person's fundamental human right. Why do you say that I'm going to hang you? Which is, hanging is cruel and inhuman treatment. So no amount of money, no amount of wealth can replace human life. Then problems of Galamsey and African Charter. You know, if you look at the problems, they are unsurmountable. Illness, death, contamination. You can count several of them. Then the African Charter, the Africans, the countries came together that let's have a treaty to bind us. And that treaty, it talks about the establishment of the African Commission on Human and People's Rights as the main protector of human rights in Africa. Then it also establishes the African Court on Human and People's Rights through the Charter. Now, the Charter is a treaty made by all the African countries to ensure that they are going to protect and preserve fundamental human rights within their respective jurisdictions. And there are 55 countries in Africa. 54 of them have signed, except Morocco. And I believe you understand why Morocco will not sign. Because of the Sahrawi Arab Republic. They will not sign. So the Charter, for example, if it is in Ghana, let me use it, and all the institutions come together that let's make a binding agreement. If we violate, you shall address us. If you are in Ghana, we say that the Constitution is the Constitution is the supreme law on the land. But if you violate, if Ghana goes ahead to execute any treaty, and that treaty is affront to a provision of the Constitution, then they will order Ghana to align its Constitution. Because nobody asks you to go and execute a treaty. So once you sign, then it is binding on you. In the African Court, that is what we do. We measure, we take all the charters that country has signed, then we match them against your laws. Do they align? If they do not align, we order you to go and amend your constitution. If you order them to go and amend their constitution, then what they will say is that it is the supreme law on the land. Yes, in your country, it is your supreme law. But at the international level, it ceases to be a supreme law. And it is subservient to the treaty that you have signed. So all the 54 countries in Africa, where any of the states violates any provision in the human rights, and the person gets the opportunity, either send the state to the African Commission or the court. We are going to measure your laws and your acts against the charter or the treaty which you are alleged to have violated. That is what we do. Then if I'm to advise government on illegal mining, my only answer is that illegal mining must stop immediately because it is about life and death. The effects, the illegal effects of mining cannot be compensated. You cannot. When you have serious illness, you give birth to a child, the child is deformed as a result of illegal mining, the chemicals that are used. Can you compensate? You cannot compensate. So illegal mining should end. Thank you.
Do we have two burning questions? Anyone for? There's one question over there.
Hello, thank you very much. I'm Veronique. I want to find out, in preparation for your paper, did you have the opportunity to consider the perspective of the miners, the people engaged in illegal mining, maybe through a paper or a survey or research that had been done from their perspective? And then what do you think is the cause of it? Because I know for Ghana, there's actively been progress to stop illegal mining. We have the laws in place. There are attempts to enforce it in court and all other places. It may not be as good as we want it to be, but there is progress being made, if it's not even at the speed that we want. What do you think is the main cause that makes it persist? Because as you said, people stop and then they go back to it. And I've had people, I've had that particular experience myself. Thank you.
Okay. I think one more. We entertain one more. We'll allow him one more question.
Thank you. So mine is not a question, it's actually a recommendation. So I want to suggest to the Academy that based on the lecture that we have had today, probably the next time we are having such a lecture, we should look at proposed solutions, which delve into comprehensive proposals that the government can adopt or can look at, given what has been done already or what is going on. And then to an extent, we should make sure that maybe the environmental minister is present, the lands and natural minister is present, because these stakeholders have a kind of a say in this whole process so that they are also able to learn from the stakeholders that are here, the experts that are speaking, to ensure that Galamsey is ended. So that's my recommendation. Thank you.
Thank you.
Thank you very much. I made some recommendations. And I made about 5 or 6 of them. Maybe there may be others, but I look at the present ones that we need as at now to eradicate it. Then from Justice Prabha, your question, perspective of illegal miners. I come from an area where they do illegal mining. So I know what it entails. On one occasion, I attended a funeral in my village. I saw people running away, helter-skelter. Then I saw excavators from the bush. I asked what is going on. Then they said, oh, the soldiers vanguard, they are coming here. And they have given information to the police. And the police have informed them to run away. So the illegal miners, they want to make money because they are in a village. All their lands have been taken over by the illegal miners. So what they also do is that if you will not stop, then I'm going to join you. So some of them are indeed afraid. If you threaten them, they will. But if you go to those areas, the people that you will find Chinese. You will find people from Nigeria. You will find Ivory Coast, Burkina Faso. Why is it that they can't do it in their own country, but they come here? So it's a food for thought. Thank you for the question.
Well, I think we've exhausted this amazing discourse. And I cannot possibly attempt to summarize this amazing lecture. I can just make a few pointers, if at all possible. For me, in education, is getting the background of promotion of human rights by Nkrumah and revisiting his record on human rights. I mean, that was an education for me, that whole process. And that, you know, the human rights is human dignity, and that he was as much for human rights and dignity than what was ascribed to him. So that elaboration in the beginning. And then and also the discourse on the Preventive Detention Act of 1958, all that. And the 1960, and then another thing of interest was that we had, First Republic, we had 1960, we only had a High Court and Supreme Court. That was also an education. And then another important take-home message for me was inscription in Arusha, and I've been there, that the African inscription in African court in Arusha, that one of the, in Africa, one of the 4 presidents, Nkrumah, is there, his inscription is there, justifying the human rights, so again, testifying his record on human rights and his advocacy. And then he came through to discuss the Nkrumah's fundamental human rights on the population, women. I mean, this is all part of his dictates, that we needed, clear food, water, and healthcare. And then promotion of human rights and advocacy. And that's this meeting in Sweden, June 5th, 16th, the common principles of human existence. And then, existence of the human rights to water, environment, clear air. This was all elaborated there. And I think the most important take-home message for me, I made a number of, was the declaration, was it the 26 Principles of Human Rights and Environment? Yes, and declaration in 1972. There were 112 votes and 10 abstentions. That man has the freedom, the fundamental right to environment, to life of dignity, protection of the environment, and for future generations. And then he elaborated on air, water, land safeguarding for future generations. Again, the environmental rights and human rights in Africa, and the rights to protect local communities and indigenous people. And we have a shout out for our own president, former president Nana S.K.B. Asante, to standing up for his community, that no galamsey in my community. So that, Nana, we applaud you for that. Yes, and he's still doing wonderful things for his community. Nana, we keep on applauding. And then discussing the African Court of Human and People's Rights, again, indicating that where we are in Africa, we have all the right things, have all the right people. Somehow we cannot make ourselves do the right things, And I think that's a question we have to ask. What's the disparity of the knowledge, all the laws, but the will to do the right thing? I can't say it's a genetic thing. It can be. But there must be something that is halting us to, go in the next step. And again, this is a very important component, that out of 55 countries, 54, so you can hold them, to account. And I think that's very important. And he's very much part of that. And then the UN Committee's July on the right to the control of environment, July 28, 2010. And then he went on water as a human right. And the most important thing is water and sanitation. And how much water we are each required. I mean, this is new to me, 50 and 100 liters per day. Even in the good households, who can guarantee? I mean, I'm always, filling my barrels with water, often so contaminated I have to refilter them again, and that we should all have safe water, 100 meters. I mean, This is all new to me, but it's all there. Ghana, we have all of this. Amazing, and our rights to safe, clean environment. And the Ghana's constitution provisions, the states and really, and how we can preserve and protect our environment. And then he went on to the scourge of Galamsey, and the Ashanti region. We did work in Ashanti region 4 years ago. And all these places that Konongo, Amanse, we were trying to provide health care and how to assess care. And now it's all damaged, all the work we did, going to households, training them how to recognize malaria fever, how to train them. We had, researchers stationed for 4 months, going around all these villages, teaching them. And it's all for naught, so, and it was funded, hugely funded. So I really feel quite sad, that we're not going forward. We just keep, and that, all the regions that have been impacted, all the Ashanti region, even the northern region, this is really just so sad for me. The premature mortality, the intervention, the land water contamination, and the health. I think the point he made is that the rich financiers, the Chinese, can we bring everyone, the government, the judiciary, can we bring everyone together that this is life or death? So we should live here really card carrying, anti-Galamsey, anti-death. I mean, this is it. So in a summary, I think we've been, treated to a wonderful lecture, importance of Galamsey and human rights, basic human rights, and that death that awaits all of us if we all don't take part in stopping Galamsey. Thank you.
Thank you, Madam President of the Academy. Thank you very much. We are almost at the end of the program, and just 2 announcements. As usual, we would like to acknowledge sponsors and also distinguished fellows and distinguished guests who have been here today. The speaker has acknowledged them already. We would like to mention that Founders Week celebration for this year was graciously sponsored in parts by our own fellow and Vice President of the Republic of Ghana, Professor Nana Jino Quakyi. As usual, we also take great pride in acknowledging the presence of our young colleagues who always join us for this program. So for today, we have Labone Senior High School here, right? You are Labone Senior High School. Yeah, we consider you treasured participants of all the academy's programs. It's my duty to also inform us that there will be light refreshment in the foyer just outside the auditorium. And for our colleagues from Labone, you have your refreshment with you so that you can get back to campus on time. Let's give our chair a round of applause for summarizing the program. And I would like to say thank you all for your presence. We appreciate it. And thank you. We invite you to always attend enlightening lectures and other activities of the academy. I wish you all a good night. And I will kindly ask that we all be outstanding as the speaker exits the podium. Thank you.